11th affirmative defense, failure to exhaust administrative remedies, as one of the affirmative defenses that the defendants attempted to plead, and I moved to strike. So, Patsy v. Board of Regents, 457 U.S. 496, explicitly held that 1983 plaintiffs need not exhaust state administrative remedies before filing suit. The Supreme Court categorically stated exhaustion of state administrative remedies is not a prerequisite to an action under 1983. The court emphasized it had on numerous occasions rejected the argument that a 1983 action should be dismissed where the plaintiff has not exhausted state administrative remedy. Congress deliberately omitted an exhaustion requirement from 1983. The court found that the 1871 Congress intended to throw open the doors of the United States courts to civil rights plaintiffs and provide immediate federal court access without administrative delays. When Congress later enacted 42 U.S.C. 1997E, creating a narrow exhaustion requirement only for prisoners, it confirmed the general no exhaustion rule for all other Section 1983 claims. The court held that a judicially imposed exhaustion requirement would be inconsistent with Congress's decision and would usurp policy judgments that Congress has reserved for itself. So then the next affirmative defense is adequate state remedy. Defendant's 13th affirmative defense asserting that adequate state remedies preclude federal civil rights claims under 1983 is legally improper and must be rejected. The Supreme Court definitively settled this issue over 60 years ago in Monroe v. Pate. Federal civil rights claims may be pursued regardless of available state remedies. The existence of state remedies is irrelevant to Section 1983 liability and damages. The Supreme Court explicitly held the federal remedy is supplementary to the state remedy, and the state remedy need not be sought and refused before the federal one is invoked. The court further emphasized that the fact that Illinois, by its constitution and laws, outlaws unreasonable searches and seizures is no barrier to the present suit in the federal court. The court's reasoning was unambiguous regarding why Congress created this supplementary federal remedy. It is abundantly clear that one reason the legislation was passed was to afford a federal right in federal courts because by reason of prejudice, passion, neglect, intolerance, or otherwise, state laws might not be enforced and the claims of citizens to the enjoyment of rights, privileges, and immunities guaranteed by the 14th Amendment might be denied by the state agencies. Monroe v. Pate, 365 U.S. 170 or 67. This holding makes clear that any affirmative defense premised on the adequacy of state remedies is fundamentally incompatible with Section 1983. Congress specifically intended federal civil rights claims to be available immediately in federal court without regard to whether state law provides remedies for the same conduct. Defendants cannot circumvent federal civil rights liability by pointing to state law alternatives. The Monroe Doctrine ensures that federal constitutional violations receive federal judicial protection regardless of parallel state remedy. So then the 19th affirmative defense, damage caps. This defense is factually incorrect. Section 1983 claims for constitutional violations are not subject to federal damage caps. The Supreme Court in Smith explicitly held that punitive damages are available in Section 1983 actions without statutory limitation. Punitive damages are awarded in the jury's discretion to punish the defendant for his outrageous conduct and to deter him and others like him from similar conduct in the future. Compensatory damages for constitutional violations, including emotional distress and dignitary harms, are similarly uncapped. Mississippi state law damage caps do not apply to federal constitutional claims brought under Section 1983. This defense improperly shifts the burden to plaintiff to disprove the existence of unspecified damage caps rather than requiring defendants to prove their existence with specific legal authority. The defense serves no purpose other than to confuse the jury about applicable law and waste judicial resources investigating non-existent limitations on constitutional damages. So it looks like I'm going now into the legally insufficient affirmative defenses, which includes the 12th affirmative defense, failure to mitigate.